He got drunk in private life. Another got thrown off the court for cussing in the courtroom. Well, that's not a crime. No, but it's bad behavior for a judge. Another one ignored an act of Congress. You see, today they do that all the time. Congress passes laws that doesn't apply to us. Matter of fact, we rule just the opposite. Got thrown off for ignoring an act of Congress. I mean, anything that was considered bad behavior for a judge was an impeachable offense. Now today, we've gone and says, oh no, maybe a criminal felony, certainly not a civil felony, and certainly not a misdemeanor. We have so changed the standard that we've told these guys they have lifetime appointments. There's virtually nothing they can do to get themselves thrown off the bench. That was not the case at the beginning. And so we have, over the course of the last 2 centuries, we have over 90 impeachment investigations. We have over 60 some odd impeachment investigations against judges, and we have over a dozen impeachments of judges. And if you look at what the causes were, it's not where we are today. Yeah. So that was one of the ways we kept them under control. There were 6 original justices appointed to the Supreme Court by President George Washington. A practice conducted under these original justices was the regular offering of prayers in the courtroom. According both to the records of the Supreme Court as well as the newspapers of the day, juries in the Supreme Court did not begin their work until after a minister had come into the courtroom and prayed for the court, for the jurors, and for their deliberations. In fact, here is a newspaper account in the Columbian Sentinel of May 16, 1792, which reports very simply, as a matter of fact, on Monday, Chief Justice John Jay gave a charge to the grand jury replete with his usual perspicuity and elegance. The prayer was made by the Reverend Dr. Parker. His Excellency, the Vice President of the United States, was in court. Our founders never saw this practice as a problem, for they never envisioned any hostility toward religion, nor any exclusion of religious faith or practice from public life. This was especially true when it came to religion and the law. The way that the judges really took to themselves this power is they have started screaming that they have the right of judicial review. And judicial review is the right for the court to be the final authority on whatever happens. The court takes that back to an 1803 Supreme Court decision called Marbury versus Madison. That is the first occasion in American history where the court reviewed the action of another branch. And what had happened, now this is 1803 when this occurs, Marbury-Madison. All the law books, all the textbooks say this is the origin of judicial review, and this is what the judges and courts rely on as being the source of their power. Let's go back to that little historical incident. You're coming at the end of the election of John Adams versus Thomas Jefferson, that 1801 presidential election. In that election, you have 2 political parties, the Federalist, John Adams, the Anti-Federalist, Thomas Jefferson. The people overwhelmingly choose the Anti-Federalist. Not only is Thomas Jefferson elected president over John Adams, but the people elected an Anti-Federalist House and they elected an Anti-Federalist Senate. So the people have weighed in. We don't want the Federalist Party, we want the Anti-Federalist Party from top to bottom. Well, you now have a lame duck president, you now have a lame duck House and Senate. They decide we're going to make sure that this nation stays Federalist and not Anti-Federalist. So they pass a bill that authorizes 16 federal judgeships, and they're going to fill those 16 judgeships with Federalist judges, and that way they can keep federalism in the government as opposed to anti-federalism. So John Adams signs that bill. He gives those positions to the Secretary of State, who has to deliver the commissions to these guys who have been named to be judge. They also passed a bill to appoint a number of judges in Washington, D.C. So he gives it to a Secretary of State. Secretary of State forgot to deliver the commissions. They didn't go to those D.C. judges. So when the new administration comes in, Thomas Jefferson, his Secretary of State is James Madison. James Madison finds these D.C. judicial appointments on his desk that they were not delivered to the previous nominees. He says, well, I'm sure not delivering to those guys. No, we don't want Federalist judges on the court. So Madison says, I'm not delivering. Well, one of the judges who had been confirmed by the Senate but didn't get his commission because the Secretary of State forgot to deliver it was a guy named Marbury. And he's the one who sued. He said, hey, I got confirmed by the Senate. I get the commission. It's been technically approved. I just don't have it in hand. So he takes it to the Supreme Court. The Supreme Court, the Chief Justice at that time is John Marshall. And the court is to decide whether this guy should have gotten his commission. Well, the court issued a ruling that said, yeah, that commission should go to him. He was given that judgeship. He should receive it. That was the ruling of the court. and that's what the court uses to say, hey, this is the first time the Supreme Court got involved in telling another branch what to do, and that's the basis. We need to say, time out just a minute. Remember that Secretary of State for John Adams who forgot to deliver the commissions? Yes. Who was his Secretary of State? It was John Marshall. John Marshall forgot to deliver them. Well, John Adams quickly appoints John Marshall over here to be Chief Justice of the U.S. Supreme Court. So the question in front of John Marshall is, you remember those commissions you forgot to deliver? Should you have delivered them? You know, today we say, time out, conflict. We have a conflict of interest here. This is a bad ethical problem. You can't rule on what you should have done back then. So here he is cleaning up his own mess that he made and saying, I rule that I should have given those to him, so you go ahead and give them to the judges in place of me. At that time, James Madison and Thomas Jefferson, President and Secretary of State, went through the roof. They said this is a complete perversion of law for the court to attempt to tell another branch what to do.
Oh, come on.
Jefferson ignored it. James Madison ignored the ruling of the court, paid no attention to it whatsoever. And by the way, that was a practice of the presidents for over 100 years. You see, if you move forward to Abraham Lincoln, the Supreme Court had ruled in the Dred Scott decision and said, you can't end slavery. You can't end it in federal territories. Blacks are property, they're not people. And Abraham Lincoln said, phew, at least it was just the Supreme Court that said that. I don't have to follow it. So Abraham Lincoln goes in and does everything the Supreme Court told him he could not do. You see, each of the branches were independent. One branch couldn't run the other two branches.
The rulings of our modern courtrooms bear little resemblance to the original intent of our founding fathers. What has affected this dramatic and historical change in our local and national courtrooms? And what is the responsibility and role of our nation's voting citizens in the judicial process? Discover our nation's godly history in the American Heritage Series. America, this is your heritage.
Before being placed on the Supreme Court by President Washington, James Wilson had signed both the Declaration of Independence and the Constitution. Only 6 founding fathers have that distinction. And at the Constitutional Convention, James Wilson had been the second most active member, speaking on the floor of the convention 168 times. James Wilson, perhaps more than any other man, is responsible for laying the early foundation for a purely American system of jurisprudence. For example, here is a 1792 commentary on the Constitution of the United States of America, of which he was a co-author. And this 3-volume set contains his legal lectures, written and delivered to students while James Wilson was sitting as a justice on the Supreme Court. In fact, Justice Wilson was responsible for starting the first organized legal training in America for law students. Notice what Justice Wilson taught his students about the relationship between law and religion.
It should always be remembered that law made for men or for nation flows from the same divine source. It is the law of God. What we do indeed must be founded on what he has done. And the deficiencies of our laws must be supplied by the perfections of his. Human law must rest its authority ultimately upon the authority of that law which is divine. We now see the deep and the solid foundations of human law. From this short but plain and, I hope, just statement of things, we perceive a principle of connection between all the learned professions, but especially between the profession of divinity and the profession of law. Far from being rivals or enemies, religion and law are twin sisters, friends, and mutual assistance. Indeed, these two sciences run into each other.
Founding Father and Supreme Court Justice James Wilson, a leading figure in the development of American constitutional law, believed and taught that all good civil law must embrace and flow from God's law.